Welcome to the law offices of Christopher A. Benson.
We are a family-owned generational law firm.
Hi, I'm attorney Chris Benson. A common question that I get is, what does estate planning mean and what is probate? So in the next 7 minutes, I'm going to tell you about both of them. Estate planning is just a shorthand phrase to refer to a collection of different legal documents. An analogy I use, it's like tools. There's not one perfect tool. If there were, we would all own that tool. It would hammer nails, and it would screw screws, and it would saw down trees, and it would paint fences. It just do everything you needed, right? Well, that tool doesn't exist. And so the same is true about estate planning, is there's not just one legal document that does everything you need. What it is a collection of different tools that you use during your lifetime. So another analogy I use, it's like shovels. When it snows, you want a big, wide, lightweight shovel so you can shovel off the driveway or the sidewalk, right? Make the job a little bit easier. Well, you could use a snow shovel to go pot your flowers in the backyard as well, but those kind of shovels don't dig so well because the metal's thin and it would remove way too much dirt anyway. What works best is a little hand spade. So you take out your hand spade, remove only the dirt you need, pot your flower, and you're done. Well, you could use a hand spade to shovel snow too, but it's not the most efficient tool. And so the same is true about estate planning. There's not just one document that does everything, and maybe you can use a power of attorney one way, or a will a different way, or a trust a different way, and maybe it'll work and maybe it won't. But that's not the idea. The idea is to use each tool for the manner that it's designed for to make it easier for you and make it easier for your family. So the cornerstone of a good estate plan for anybody who owns real estate is a trust. And the reason is a trust does many different things. It's not all about dying. So a trust is an agreement that you make where you are the trustor. That's the person or the people that create a trust. And then the second role is the trustee. That's like the president of the company. That's the person or the people that have legal authority to take action on behalf of the assets that are owned by the company. And the third role is the beneficiary. And that's the person or the people that have the right to use the assets that are owned by the company. Well, in the beginning, you're all three. You create the trust as the trustor, you appoint yourself as the president of the company as the trustee, and you are also named as the beneficiary who has the right to use the assets. You can add assets to the trust, you can spend money, you can transfer assets, you can sell them, you can add to it, you can gift property away. Anything that you can do now, you can do it through the trust. But like I said, it's not all about dying. We're seeing people live a lot longer but lose the mental ability to manage their assets. So if that happens to you, you designate a successor trustee to step into your shoes and manage your assets for your benefit. The same is true if you're married. If one spouse becomes medically unable to manage their assets, then the competent spouse can manage the assets that are owned by the trust for the benefit of the incompetent spouse. If one of you passes away, the value of all assets are stepped up to the value date of death. The surviving spouse has the right to use the asset and becomes the sole trustee as well. When both of you pass away, the value of all assets are stepped up a second time to the value date of the second death, and whoever you picked as your successor trustee automatically steps into your shoes and becomes the new president, and they can manage the assets for the benefit of the beneficiaries that you designate. Now, a trust by itself isn't good enough. You also need a will. The will is there as a safety net in case you goof up, in case you forget to put all of your assets into the trust. Now, there are different ways to avoid probate, but the question becomes, well, what does probate mean? Well, probate is a simple idea. Probate is taking title of assets from a deceased person and giving them to people who are alive. Now, everything has title. The pen on your desk, who has title to the pen? All it means is ownership. Who owns the pen? Or the desk itself? Who owns the desk? Or the house that you're in? Who has title to the house? Or the car that you drive? Or the money in the bank? Everything has title. Well, when you die, you can't write with the pen anymore. So we need to give the pen to somebody who's alive, because if you're alive, you can write with the pen, or use the desk, or live in the house, or spend the money, or drive the car. Well, some concepts are simple, but they're difficult to execute. So I'll give you another example. It's like, I want to go to the moon tomorrow, right? Simple idea. I'm going to go to the rock in the sky tomorrow. Well, execution's a little more difficult. I have to get a rocket, and I gotta get a helmet, and I gotta get a suit and some food and some things. So just because it's a simple idea doesn't mean it's easy to do. So I don't want you to think that probate is rocket science. It's not. But there's more to it. You gotta hire a lawyer. You have to file pleadings with the court. Everything that you file with the court is open to the public. It's public record. You have to tell everybody in the world all the assets that you own, what they are worth, and everybody that you owe money to. Most people don't like that idea. So the deal is with a trust, the trust doesn't die. So when you transfer title of assets from your name to you as trustee of your trust while you're alive, and then you pass away, there are no titles left to move through the probate court to living people. And the reason is you already did it. So when you hear people say the phrase that a trust avoids probate, what they're really saying is that the trustor died, all the titles were owned by the trust, and no titles were owned by the person who passed away. Now there's other ways to avoid probate as well. Life insurance proceeds are paid automatically directly to the named beneficiary. That passes outside of the trust and outside of a will. IRAs, 401k, retirement accounts, pensions, those go directly to your named beneficiaries. So you want to make sure that you have beneficiaries named for all those type of assets. You can have a bank account that is a payable on death bank account to named beneficiaries, and all of those methods avoid probate as well. The problem with the bank account though is that if you pass away, title of the money moves to your beneficiaries, but it doesn't address the fact if you're alive but become medically unable to manage your assets. In that situation, if the bank account's owned by the trust, you're fine, or if you have a financial power of attorney, then you're fine. Then the money can be used for your benefit as well. So doing estate planning, it's not a light switch. It's not all one way or all another. Frequently it's a blend. Some assets are going to be in a trust, some assets are going to be in your own name but have payable on death beneficiaries, and that's totally fine. Now, a second tool that I give you is a will. The will is there as a safety net. In case you goof up, in case you forget to put an asset into the trust, well, sure, your executor is going to have to hire a lawyer and do a probate regarding those one or two assets that you goofed up on, but not all of your assets, not any assets that are owned by the trust, not any assets that have payable and death beneficiaries. So most people can avoid probate. The third tool I give you is a financial power of attorney. So if you're unable to make your own financial decisions, then you've got people in place to make financial decisions for you. Manage bank accounts, as I described earlier. I also give you a healthcare power of attorney. If you're unable to make your own healthcare decisions, then you've got people in place to make healthcare choices for you. Along with that, I give you a HIPAA healthcare release. The HIPAA healthcare release allows people access to your medical records so that they can contact your doctor, schedule doctor appointments, attend doctor visits with you, pick up your prescriptions, anything that they need to do to help manage your healthcare. The HIPAA healthcare release allows them to do that. I also do a designation of guardianship for you. A guardianship has nothing to do with money. It has nothing to do with healthcare choices. It means who takes care of you as a person, who makes sure that you've got a place to live and food to eat and clothes to wear. And then the last thing I give you is a living will. And in a lot of places it's called a directed to physicians. And those are end of life choices. So if there's certain things that you do or do not want, so if you don't want CPR, or you don't want dialysis, or you don't want a blood transfusion, all those different elections you can make. All of those things come together to make a complete estate plan. And as you can see now, one document by itself doesn't handle the other things that you need to handle. I hope this clears up a little bit of the mystery concerning what estate planning really means and what probate is about. You can contact me at my website, www.cbenson.com, or you can call one of our office locations. Thank you.